Yeah, I'm going to start polity. Okay, so very first preamble of our constitution. We, the people of India, have solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our constituent assembly, this 26th day of November 1949, do hereby adopt, enact, and give ourselves this constitution. Drafting committee members are Dr. B. R. Ambedkar and Gopalaswamy Iyengar, Alladi Krishna Swamy Iyengar, K. M. Munshi, Syed Muhammad Singh Abdullah, and Madhva Rao in place of B. L. Mitra, and D. P. Khaitan after his death of T. Krishnamachari. Okay, after his death, T. Krishnamachari was the drafting committee members. Now, committees I'm going to tell you, and then some the chairman of that committee. So, Union Power Committee and Union Constituent Committee. These two headed by J.L. Nehru. Then Fundamental Rights and Minority Committee plus Provincial Constitution Committee headed by V.B. Patel. Then Drafting Committee B.R. Ambedkar, Flag Committee J.B. Kripalani, Steering Committee K.M. Munshi, and Constitution Advisor B.N. Rao. When our constitution adopted, then a preamble was there, 395 articles were there, and 8 schedules were there. Some salient features of Indian constitutions are fundamental rights, fundamental duties, directive principles of a state, universal adult franchisee, 3-tier government, independent bodies like EC, CAG, UPSC, PSC, emergency provisions were there, a parliamentary form of government, federal system with unitary bias, a secular state, lengthiest constitution drawn from various sources, blend of rigidity and flexibility, and single citizenship. Then I'm going to tell you schedules of constitution. Okay, so what are the schedules in our constitution? First schedule related to states and union territories. Second schedule, salary of president, governor, CJ, judges of HC and SC and CAG. Then third schedule, forms of oaths and affiliations. Fourth schedule, allocate seats for each state of India in Rajya Sabha. Fifth schedule, administration and control of scheduled areas and tribes. Sixth schedule, provision for administration of tribal areas Assam, Meghalaya, Tripura, Mizoram, and Arunachal Pradesh. Then 7 schedules related with the gives allocation of powers and functions between union and states. Contains 3 lists: union list, which is having 98 subjects; state list, which is having 62 subjects; is concurrent list, which has 52 subjects. 8th schedule, list of 22nd yani 22 languages of India. 9th schedule, added by First Amendment in 1951. First Amendment in 1951 contains acts and orders related to land tenure, land tax, and railways, etc. Then 10th schedule, added by 52nd Amendment in 1985. 52nd Amendment in 1985 contains provisions of disqualification on the grounds of defecation. Then 11th schedule. Now, 10th schedule, one more thing I want to tell. 10th schedule is decided by the chairman in the case of Rajya Sabha and speaker in the case of Lok Sabha, not by the President of India. Okay. It means the ground of defecation decided by the chairman and speaker, not by the President of India. Then 11th schedule by 73rd Amendment in 1992 it contains provision of Panchayati Raj. And then 12th schedule by 74th Amendment in 1992, which added here municipal corporation. Now, sources of constitution. Sources में Government of India Act, you can say in short form FJEL, FJL. Okay, Government of India Act, FJL. FJL means Federal System, Judiciary, Emergency Provisions, and 3 lists. Okay, then from UK, we can say from UK, we can having a short trick, Parkabids. And Parkabids means Parliamentary System, Cabinet System, and bicameral system, parliament, bicameral parliament, and citizenship. Then from US, you can say the short form of pre-FR ex officio. Okay, pre-FR ex officio. It means very first written constitution were there in US and Indian both. Then FR means fundamental rights. Then preamble was also taken from there and from US, and the ex officio vice president as ex officio member of Rajya Sabha. Then from Irish constitution, we took directive principles of state policy and election of president, also method of election of president. Then from USSR, or you can say Russia, we took up fundamental duties and 5-year plannings. And from Canada, federation with strong state and appointment of governor by center. Then from South Africa, procedure of amendment in constitution. Okay, then from by Japan, procedure established by law. And from Australia, concurrent list, joint sitting of 2 houses. From Germany, suspension of fundamental rights during emergency. I want to say one sources of constitution I left out. From French constitution, we took republic and the ideals of liberty, equality, and fraternity in the preamble. Now, Constituent Assembly adopted national flag on July 22, 1947, national anthem on January 24, 1950, national song on January 24, 1950. The question as to whether the preamble can be amended under Article 368 of Constitution arose for the first time in the historic case Keswa Chandra Bharti 1973 case is there. It was urged that the preamble cannot be amended as it was not a part of Constitution. In 1976, 42nd Amendment, Constitution Amendment Act added 3 new words to the preamble: socialist, secular, and integrity. What are the criticism of Constituent Assembly? That it was time consuming, dominated by Hindus, political domination was there, domination by Congress, not a representative body, not elected people were there, and not a sovereign body. Citizenship Act of 1955. So I'm not going to deal with it. Now some points. Article 3 authorized the parliament to form a new state, increase the area, diminish the area after the boundaries, alter the name of any state. Article 4 declares these points are not to be considered as amendments of constitution under Article 368. Of the 552 princely states, 549 joined India and remaining 3 refused to join India, which were integrated with India: Hyderabad by means of police action, Junagadh by means of referendum, and Kashmir by instrument of annexation. In 1953, Government of India was forced to create the first linguistic state known as Andhra state by separating the Telugu speaking areas from the Madras state. K.M. Panikkar and H.N. Kunguru and the chairman Fazal Ali broadly accepted language as the basis of reorganization of states, but it rejected the theory of one language, one state. As a result, 14 states and 6 UTs were created on 1st November 1956, and that was Fazal Ali Commission. Okay, that was there. So what are the, according to State Reorganization Act, in 1953 Andhra Pradesh was become a state, 1956 Kerala and Karnataka, 1960 Gujarat and Maharashtra, 1962 Nagaland, 1966 Haryana, 1970 Himachal Pradesh, 1971 Meghalaya, Manipur and Tripura, then 1975 Sikkim, 1986 Mizoram and Arunachal Pradesh. Okay, 1987 Goa, 2000 Chhattisgarh, Uttaranchal and Jharkhand. RTI Act, October 2005, RTI Act was made a constitutional act. It is corollary of fundamental rights of freedom of speech and expression, Article 19A. Information Commission has been set up, which consists one Chief Information Commission (CIC) and 10 Central Info Commissioners. They shall be appointed by President on the recommendation of committee consisting of PM, the leader of opposition, and Union Cabinet Ministers. CIC term is of 5 years till the age of 65. Reappointment not allowed. CI Commission can find 250 rupees per day to 25,000 rupees if information is delayed beyond stipulated time of 30 days. Part 3, Fundamental Rights. Here, Article 12 to 35 was discussed, and fundamental rights were taken from USA. Okay, and it's justicable. So, Article 13 declares constitutional amendment is not a law, hence can't be challenged. Now, right to equality is from Article 14 to 18. Here, equality, or you can say protection before law in Article 14. Then prohibition of discrimination on the grounds of religion, race, caste, sex, or place of birth in Article 15. In Article 16, equality of opportunity in employment. And in Article 17, prohibition and abolition of untouchability. And Article 18, abolition of titles except military and academic. So in the short, you can say, if you want to learn, it's like please don't eat unwrapped toffees. So please means you can say prohibition protection before law, Article 14. Don't, D is discrimination on the backgrounds of race, caste, and sex. Then eat, E is opportunity of employment. Then unwrapped, U untouchability. Okay, abolition of untouchability. And toffees, T is abolition of titles. Now right to freedom of speech, expression, assembly, association, movement, residence and profession. Okay, in Article 19 it is mentioned. And in Article 20, protection in respect of conviction for offences. And Article 21, protection of life and personal liberty. So note in article not violated in emergency. So Article 20 or 21 not violated in emergency. Right to elementary education in Article 21A. Okay, protection against arrest and detention in certain cases. Protection against arrest and detention in certain cases in Article 22. So if you want to have a short trick, it's सारे आम ripe हैं, offense life, education then by 8 grass. Okay, तो इन सारे आम, sa means speech, means assembly, association and movement. Then ripe means you can say residence and profession. Okay, freedom of profession. Then protection in respect of conviction for offences. O is there. Okay, then 8 grass, it means like arrest. Okay, this much is like that. Then Article 23 and 24 is related to right against exploitation. 23 is prohibition of trafficking and for forced labor, prohibition of employment of children in factories in Article number 24. Right to freedom of religion, freedom of concise, free profession, practice and propagation of religion in Article 25, freedom of manage religious affairs in Article 26. Article 27 is about freedom from payment of taxes for promotion and freedom from attending religious instruction or worship in a certain educational institution in Article 28. Okay, then cultural and educational right in Article 29 and 30, protection of language, script and culture of minorities in Article 29, and in 30 article you have right of minorities to establish and administer educational institutions. Article 31, right to property made legal right and deleted by 44th Amendment Act 1978. And Article 6 fundamental right, 6th is your right to constitutional remedies. This is the soul of constitution. Okay, in Article 32 it is right to move the Supreme Court for the enforcement of fundamental rights, including the writs of habeas corpus, like to have the body. It means you can go against public authorities as well as the private individuals. Okay, you can ask, one can inquire under what authority he has been imprisoned or detained. So this is the habeas corpus. In mandamus, we command by the court command a person or public authority to do, or for beer to do something in the nature of a public duty in quo warranto, or you can say by what authority or warrant. So by this writ the court can prevent a person from holding office. Prohibition to forbid. Okay, so it is issued only against judicial and quasi judicial authorities. It is issued by SC or HC to an inferior court, forbidding the latter to continue proceeding in excess of jurisdiction. Then it is not available against administrative authorities, legislative bodies, and private individual or bodies. Then in certiorari, or you can say to be certified, to be informed, it is issued by HC to lower one or to transfer case pending with the letter to itself, or in quas it is quas the order of the letter in the case. Freedom of religion, cultural and rights, a short trick is there. PMT देने से पहले you need to say I love you. So in that PMT, educational rights, so PMT means protection of language, okay, script and culture, and this much is there. And for love is that I love education. Okay, so for I, it is for I. Okay, just leave it. Then fundamental rights to property, Article 31 was deleted by 44th Amendment Act 1978. It made a legal right under Article 300A in Part 12th. It is now a legal right. Article 13 declares a constitutional amendment is not a law and hence cannot be challenged. Mandal Commission. What is Mandal Commission? Second Backward Class Commission, Chairman BP Mandal, submitted report in 1980 and identify as many as 3,743 castes as socially and educationally backward classes. The commission recommended for reservation of 27% government jobs for OBCs. Ramnandan committee was appointed to identify the creamy layer among the OBCs. Okay, so in this 3,743, 52% of OBC excluding SC and STs. Okay, it is constituted. Then first backward class commission on set up a commission of Kaka Kalkar 1953. It is for 10 years in 1990. After 10 years, 1990, VP government declared 27% government jobs for OBCs. Okay, 1990 VP government declares 27% government job in for OBCs. Then Article 33 empowers the Parliament to restrict, abrogate, or fundamental rights of the members of armed forces, paramilitary forces, police forces, intelligence agencies. Okay, so it restricts freedom of speech, association, communicate with the press, attend public meetings and demonstrations. Some preventive detention laws made by the Parliament are Prevention of Smuggling Activities Act POSA 1974, National Security Act NASA 1980, Terrorist and Disruptive Activities Act TADA 1985, Prevention of Terrorism Act POTA 2002. Criticism of fundamental rights. So we have some criticism also here, like excessive limitation, no social and economic rights, no clarity, no constituent philosophy, preventive detention, excessive remedy, right to move courts. Okay, expensive remedy it is, and then a suspension during emergency, no permanency. Okay, so this much is all about fundamental rights. Now one more thing I want to say, then in Article 21, protection of personal liberty means right to live with dignity, right to decent environment, right to livelihood, right to privacy, right to shelter, right to health, right to formation, right to fair trial, right to travel, right to proper medical aid, and etc. So this one is an article. I'm going to tell you something about directive principles of state policy. It is mentioned in part 4th, article 36 to 51, and it was taken from Irish and Spanish constitution. Noble features by Dr. B.R. Ambedkar said, and concise of the constitution also. Then they are instructions to the legislature and executive. Features non-justificable instrument of instructions to the legislature and executive. It constitutes a very comprehensive economic, social, and political program for a modern democratic state to promote welfare and to secure the right to work, education, and many more. So, from Article 38, to promote the welfare of people by securing a social order. Article 39, the state will secure right to adequate means of livelihood, equitable distribution of material resources, equal pay for equal work for men and women, opportunity for healthy development and of children. Article 39A, equal justice for and free legal aid. Then Article 40, to organize village panchayat as units of self-government to secure right. Then Article 41, to secure right to work or to education for all. Article 42, to secure just and human condition of work and maternity relief. Then Article 43, to secure work, living wage, labor, and in particular to prompt cottage industries. Okay, and then in 43A, participation of workers or employers in management of industries. 43B, promotion of cooperative societies. Then Article 44, to secure a uniform civil code applicable to the entire country. Then Article 45, to provide early childhood care and education for all children, free and compulsory education up to age of 14. By 86th Amendment Act 2002 it was added. Okay, then Article 46, promotion and education and economic interest of SC, ST and other worker sections. Then Article 47, duty of the states to raise the level of nutrition and the standard of living and to improve public health. Article 48, organization of agriculture and animal husbandry. Article 48A, protection and improvement of environment and safeguarding of forests and wildlife. Then Article 49, protection of monuments and places, objects of national importance. Article 50, separation of judiciary from executive. Article 51, promotion of international peace and security. So all these are the important articles. These articles are also divides in three parts: socialist principle, Gandhian principle, and liberal and intellectual principles. So I'm going to tell you these parts according to the articles. So in socialistic principles, we have Article 38, which is about the welfare of people. Then Article 39, equitable distribution. Article 39A, equal justice and free legal aid. Article 41, a right to work and education for all. Article 42, just and human condition for work. Article 43, living wage, and Article 47, level of nutrition and public health. So it means Article 38, 39, 39A, 41, 42, 43 and 47 related to socialistic principles. Now I'm going to tell you something about Gandhian principles. These articles are Article 40, village panchayat. Article 43, living wage. 43B, participation of workers in the management of industries. Article 46, interest of SC and ST. Article 47, level of nutrition and public health. Article 48, organization of agriculture and animal husbandries. Then liberal and intellectual principles are Article 44, secure and uniform civil code. Article 45, compulsory education for up to age 14. Article 48, organization of agriculture and animal husbandry. Article 49, protection of monuments and places. Article 50, separation of judiciary and executive. Article 51, promotion of international peace and security. Okay, so this much is all about articles. Okay. Now, the Gandhian principles are carried from Article 40, 43, 43B, 46 and 47 and 48. Now, something very important about fundamental duties. It is also the part 4th and it is named as part 4th A and Article 51A. Okay, so it was taken by the Constitution of USSR. Okay, in 1976, fundamental duties were added to the Constitution, non-justificable, enacted by 42nd Amendment Act of 1976. On the basis of Swarna Singh Committee report, he recommended 8 duties. Okay, now these are 11. but he recommended only 8 duties. So what are 11 duties of fundamental duties? Respect constitution, national flag and anthem. Second, follow noble ideals and inspired our national struggle of freedom. Then third one, uphold and protect the sovereignty, unity and integrity of India. Fourth, to defend the country and render national service when called upon. Fifth, to promote harmony and brotherhood and protect the dignity of women. Sixth, to value and preserve the rich heritage and culture. Seventh, to protect and improve the national environment. Eighth, to develop scientific temper, humanism and spirit of inquiry and reform. Then ninth, to safeguard public property and adjure violence. Then 10th, to strive towards excellence in all spheres and individual and collective activity. And 11th, to provide opportunities for education to his child or ward between 6 to 14 years. It was added in the 86th amendment of the constitution in 2012. So I think this much is okay for you, but two more information was there. Verma committee observation and the representation of People's Act. So the existence of legal provisions for the implementation of some FDs or fundamental duties, they are mentioned below in Verma committee observation. The Prevention of Insults and National Honor Act 1971, the Protection of Civil Right Act 1955 provides for the punishment for offences related to caste and religion. The Unlawful Activities Prevention Act of 1967 for communal organization, IPC declares the imputation and assertion prejudicial to national integration as punishable offences. Center and state relations. These are mentioned in Article 245 to 255. So these are divided in three parts: legislative relationship and administrative relationship and financial relationship. So legislative relationship mentioned in part, we can say 11th in Article 245 to 255. The Constitution divides the subjects into Union List, State List and Concurrent List. Union List somehow at this time having 97 subjects. It contains defense, currency, citizenship, foreign affairs, communication, interstate parade or commerce, banking, atomic energy, post and telegraph, census, then audit and so on. Then State List contains 66 subjects, and these are like public order, police, prison, local government administration of justice, agriculture, public health, sanitation, markets, irrigation, theatres and so on. Then concurrent list, both parliament and state legislature make laws to these subjects. These are having 52 subjects, earlier 47. It contains criminal and civil laws, forest, education, marriage and divorce, drugs, trade unions, newspapers, printing press, population control, family planning, electricity and so on. 42nd Amendment of Act 1976 transferred 5 subjects to concurrent list to from state list. So from state lists, concurrent some subjects transfers to concurrent list. So these are education, forest, weight and measures, protection of wild animals and birds, and administration of justice. Constitution and organization of all courts except the Supreme Court and High Court. Then residual power, the subjects not included in any of the list is already rest with the union government. So Parliament can make laws on any matter enumerated in the state list under the following 5 circumstances: when Rajya Sabha passes a resolution during national emergency, when a state makes a request or to implement international agreements, or during presidential rule. Now the B, I'm going to discuss administrative relationship. These are mentioned in part 11th, Article 256 to 263. Constitution has a strong bias towards the center to make it strong. The central administration prevails over the state administration. Center extends to the exercise of right, authority and jurisdiction, means executive powers conferred on it by any treaty or agreement. Center has power to give directions to the state matters about the construction and maintenance of means of communication, railways within the state, instructions of mother tongue, scheme for the welfare of ST in the state. So maintenance of communication, railways, welfare of state, mother tongue, center can give some directions. Then a law made by parliament on a subject of any union list can confer power and impose duties on the states too. The same thing cannot be done by the state legislature. The mutual delegation of functions between center and state can take place either under an agreement or via legislation, while and center can use both the method. By states can only use the first method. So a law by center confer over a state, but vice versa not allowed. Okay, so the next point is there in the administration relationship. Center and states both have their separate public services, so like all India services, IS, IPS, IFS. They occupy top position under both the center and states, but they are recruited and trained by center. The chairman and members of the state PSCs appointed by governor of the state can be removed only by the president. Okay, separate public services, these are also the form of administration between these two. Then center, in center you can say HC is there, you can say central supreme court, and in states high courts were there, or lower courts also there. So India has integrated judicial system. SC is at the top and SC at the top and HC at the below. Then centers extra constitutional devices like Niti Aayog or Planning Commission, NDC, National Integration Council, University Grants Commission, Central Family Welfare Councils, and so on, for promoting cooperation and coordination between the center and states. So extra constitutional devices for coordinated, or you can say coordination of between center and states. So this is all about administrative relationship. Now I'm going to tell you some are financial relationship between these two. States are greatly dependent on the center for subsidies and contribution. Union exercise control through CAG, or Comptroller Auditor General, who audits states accounts, appointed for the Finance Commission by President every 5 years, also adds to it. Article 268 provides a scheme of the distribution of revenue between union and states. The union and states exercise to proceed of the taxes in the union list and state list respectively. The concurrent list includes no taxes. So revenue distribution between center and states were there, and the concurrent list includes no taxes. This is very important point. Constitution mentions 4 categories of union taxes, which are wholly or partially assigned to the states. Duties levied by the union but collected and appropriated by the states: stamp duties, excise and medicinal duties. Now it is somehow you can change GSTs. Whenever GST we are talking about GST, so it's changed all the earlier phenomena. Taxes levied and collected by the union but assigned to the states. So state duties of property and taxes, goods and passengers carried by the railways, taxes on stock exchanges, taxes on the sale and purchases of newspaper, and on add therein. The taxes levied and collected by the union and distributed between taxes levied and collected by union and distributed between union and states. Income tax not included corporation tax. And taxes are collected by unions and may be distributed between union and states. Custom and excise duties under those on medicinal and toilet preparations as are mentioned in union list. Apart from these, centers also has passed to grant loans and provide grant in aid. Article 275 to the states, especially for the purposes of promoting the welfare of ST and SC, raising the levels of administration of scheduled areas. So this is in fact the most important sources of income for the states. So center has the power to grant loans and grant in aid. Sarkariya Commission is there after the to view center and state arrangements. Sarkariya Commission appointed in 1983 after demands of greater autonomy in the states. Appointment was there in 1983 under Justice Sarkariya. The commission submitted its report on October 27, 1987. This commission was asked to examine and review and the working of existing agreements, or you can say arrangements, between the center and the states in all spheres, and recommend appropriate changes and measures. The commission made 247 recommendations, in which 180 has implemented till 2011. So important recommendations are intergovernmental councils should be set up under Article 263 consisting PM and CMs, and then Article 356 presidential rule should be used very separately as a last option. All Indian services should be further strengthened, and some more such services should be created. Three language formula should be implemented. The residuary power of taxation should continue to remain with the Parliament. NDC, National Development Council, should be renamed and reconstituted as the National Economic and Development Council. NEDC, central control over radio and TV should be relaxed. Suggested activation of zonal councils. Center should consult the states before making laws on subject of the concurrent list. Corporation tax may be primarily separable with the states. Government's term 5 years should not be distributed except for some extremely compelling reasons. Okay, disturb, sorry, not as distributed, disturb, it should not be disturb, government's term. Then the commissioners for linguistic minority should be activated. Governor can't dismiss council of ministers without majority of the assembly. Judges of HC should not be transferred without the consent, and no changes in the role of Rajya Sabha and center powers to recognize the state. So here I'm going to tell you something about emergency. Okay, so comparison between national emergency and president's rule, and what is financial emergency. So national emergency is mentioned in Article 352 and president's rule mentioned in Article 356. So I'm going to tell you some comparative study between these two. When nation threatened by war, external aggression or armed rebellion, so that is national emergency. And when the state government can't carry it on in accordance with constitution, its governance, then president's rule may be imposed. Then in national emergency, state executive and legislature continue to function and exercise the power assigned to them under the constitution. But in president's rule, the state executive is dismissed and the state legislature is either suspended or dissolved. The president administered the state through the governor. So in the national emergency, parliament can make laws on the subject enumerated in the state list only by itself. In the president's rule, the parliament can delegate the power to make laws for the state to the president or to any other authority. In national emergency, operated indefinitely with the approval of parliament for every 6 months, but in president's rule maximum period is 3 years. After then it is not allowed. Okay, then in national emergency, relationship of center with all states undergoes a modification, but in president's rule only the state under emergency with the center undergoes a modification. In a national emergency, every resolution of parliament must be passed by a special majority, and here in president's rule every resolution of parliament can be passed only by the simple majority. Then it affects national emergency, of course it affects fundamental rights, but in president's rule doesn't affect any fundamental rights. In national emergency, Lok Sabha can pass a resolution for its revocation, and president's rules revoked by the president only on his own. Okay, national emergency can be declared only on the occurrence of the cabinet and not merely advice of the PM. Okay, but in president's rule, first time the president's rule was imposed in Punjab in 1951. Okay, so first time president's rule imposed on Punjab in 1951. National emergency can be challenged in the court on the ground of malafide. Okay, malafide. In Articles 360 empowers the president to proclaim a financial emergency too. Proclamation of emergency must be approved by both of the houses of parliament within 1 month from the date of its issue. In a president's rule, a 44th Amendment Act of 1978 implying that the satisfaction of the president is not beyond judicial review. Then Article 20 and 21 remain enforceable even during an emergency, national emergency. Okay, national emergency has been proclaimed 3 times so far. 1962, okay, is this somehow you can say external aggression. 1962, Chinese aggression in northeast frontier agency in Arunachal Pradesh till 1968. And then in 1971, in the wake of attack by Pakistan, June 1975 again, June 95 to June 1975 to 1977, it is internal disturbance. Most controversial, Indira Gandhi lost power, Janata Party came to the power. So these three dates, you can say 1962, 1971 and 1975 are the years where national emergency imposed. Financial emergency, no fixation of maximum period prescribed for its operation. Okay, so no period was prescribed for financial emergency. Then repeated parliamentary approval is not required for its continuation, and no financial emergency has been declared so far, though there was financial crisis in 1991. So it's all about your emergency are the very life or life breath of the constitution. Okay, and for emergency safety valve, emergency is like a safety valve. It is told by Mahavir Tyagi, okay, and by Krishnam Swami Iyer, emergency, the very life breath of the constitution. So here I'm going to tell you something very important about the president. Okay, so in Union Executive, Article 52 to 78, you can say discussed about executive, and Article 52 especially discussed about president. What are the characteristics? Must be a citizen of India, age 35 years at least, term 5 years, you can say. Must not hold any office of profit, eligible to be a member of Lok Sabha executive head, salary 150 lakh per month, the pension is 50% of the salary, can give resign to vice president before its full term, indirectly elected through electoral college consisting MLAs and MPs, no nominated members were there, and MLCs have no right to vote in presidential elections. The value of the vote of MLA from UP has highest value that from the Goa. It means which is having highest population, that states MP is having MLA has more value. Okay, more value of its vote. Each voter is entitled to cast as many as votes as there are candidates in the field, indicating the order of his preferences. Then presidents, in the case of president's office falls vacant, the vice president acts as president. If he is not available, then chief justice of Supreme Court can be do this same job. The election is to be held within 6 months of the vacancy. Then what are the special powers president has? So every first executive powers, appoints PM, ministers, chief justice, judges of SC and HC, chairman and members of UPSC, CAG, attorney general, chief election commissioners, and members of election commission, governors, members of finance commission, ambassadors, and etc. In legislative powers, President can summon both the houses and dissolve Lok Sabha, nominates 12 members in Rajya Sabha, and nominates 2 members of Anglo-Indian community in Lok Sabha. 12 members in Rajya Sabha and 2 members in Lok Sabha. Be remember, okay, he has 3 types of veto power: absolute veto, suspense veto, and pocket veto. So what is absolute veto? Absolute veto, withholding the assent to the bill. Okay, so you can it simply say assent, or you can say yes. Then a suspense veto, president returns the bill or a part of it for the reconsideration. And pocket veto, constitution does not provide any time limit, so that is very important. Constitution does not provide any time limit within which the president is to declare his assent or refusal. Okay, so that is very important. Then about president, the central legislation. So in the central legislation, 3 types of bills are there. So just look at what are the considerations. With regard to ordinary bill, president can ratify it, or you can say approved that thing, or can be rejected, or can be returned. So ordinary bill, it might be ratified, it might be rejected, or it might be returned. But with regards to money bill, can be ratified, yes or no, or can be rejected. It can't be returned. Be careful. It it can't be returned by the president. Only he can be ratified or rejected. With regard to the constitutional amendment bill, can only be ratified. That cannot be rejected and returned. Ratified means he should give the approval of that constitution amendment bill. He cannot say yes or no. He cannot reject it. He cannot return it. So just keep it in your mind. Money bill, he can't be returned, and amendment bill, he can't be rejected or returned. He should be ratified, or he should give his approval on that constitution amendment bills. Then financial powers, money bills can be introduced with his prior recommendations. No demand for the grant can be made except on his recommendation. He can make advances out of the contingency funds of India to meet any unforeseen expenditure. He constitutes a finance commission after every 5 years. In military powers, you can say he is the supreme commander of defense forces of India, appoints chief of army, navy and air force, declares war and concludes peace subject to approval of the parliament. Then financial power. The President's pardoning power comprises a group of analogues. So these are pardon, reprieve, remission, respite and commutation. So what is means of pardon? It completely absolves the convict from the all sentences, punishment and disqualification. So he could simply say pardon. It is in criminal cases also. Reprieve, it implies a stay of the execution of the sentence. Okay, a stay. You can say a break. It waits for the pardon or commutation from president. Okay, so it waits for that. Then remission, it implies reducing the period of the sentence without changing its character. So the period reducing is done by remission. Then in respite, it denotes awarding a lesser sentence in place of one originally awarded due to some special fact. Lesser sentence by the respite. And commutation, it means it denotes a substitution of one form of punishment for a lighter form of punishment. So these are there. So one is quick recap: pardon, completely absolve; reprieve, a stay on the punishment; remission, reducing the period; respite, a lesser sentence; and commutation, a substitution of that punishment. Then president can proclaim national emergency in Article 352 on the ground of security threatens to India by war, external aggression or armed rebellion. It can be approved by the parliament within 1 month. It will be continued for 6 months. It has proclaimed 3 times: 1962, 1971 and 1975. President can suspend fundamental rights except Article 20 and 21. And Article 20, protection in respect of conviction for offences, and in Article 21, protection of the life and personal liberty. So these two articles cannot be suspended. Okay, Article 19, freedom of speech, assemble and association can only be suspended in the case of external emergency and not in the internal emergency. The state emergency, or you can say president's rule, in Article 356, it was mentioned due to failure of constitutional machinery in states. President's rule, it might be proclaimed there. President's rule should be approved by the parliament within 2 months. It can be extended for a maximum period of 3 years, as I already told you, with the approval of parliament every 6 months. State governor carries the state administration. Financial emergency, Article 360 is there. It can be proclaimed when financial stability is threatened. It must be approved by parliament within 2 months. It has not been declared so far in India. So 42nd Amendment Act 1976 made obligatory advice of Council of Ministers on the President. Then Article 74 stated advice of PM and Council of Ministers should be done. 44th Amendment Act further states that President can bend the advice back for reconsideration, but only once. So this is all about. Now here we are going to discuss about what is governor and what are the characteristics of governor. So governor age should be 35 years, must be a citizen of India, 5 years is the term, and must not be hold any office of profit. Should not be a member of either House of Parliament or a state legislature. Salary should be 1,10,000 per month from Consolidated Fund of India. Can give resign to President. The legislature, High Court has no rule in it. No rule in it. Not fixed term. He may be removed by the President of India anytime. Appoints Chief Minister, Council of Ministers, Chairman and members of Supreme Courts, Advocate General of State, State and EC of Election Commission of State. Then it also appoints 1/6 member of Legislative Council. Governor, he should not belong to the state where he is appointed. That is very important thing. Then it can nominate one member from Anglo-Indian community. When the president's rule is in the progress, he becomes the agent of union government in the state, act as chancellor of the state universities and appoints vice chancellor. All money bills can be introduced on his recommendation. Sarkaria Commission suggested that Chief Minister should be consulted while appointing governor. Active politician should not be appointed as governor. Removal should be difficult. No need to remove the post of governor. So that is suggested by or recommended by Sarkaria Commission. 7th Constitutional Amendment Act of 1956 facilitated the appointment of the same person as the governor for 2 or more states. So one person can be a governor of 2 or 3 or 4 or maybe more states. So in which constitutional amendment? 7th Constitutional Amendment Act of 1956. So this is all about governor. Now some points about vice president. It is mentioned in Article 63. It is also having the same characteristics like must be citizen of India, 35 years of age, 5 years of term, and must not hold any office of profit. Then vice president processes the qualification for membership of Rajya Sabha. Salary 1,25,000 per month. The pension is 50% of the salary as the chairman of Rajya Sabha, not as the vice president. Elected by both of the houses with the help of electoral college in accordance with the system of proportional representation by means of single transferable vote, and nominated members also participated in this election. Can discharge the function of president if the post falls vacant for maximum 6 months. Then when he discharges the function of the president, the vice president shall not perform the duties of the office of chairman of Rajya Sabha, and shall not be entitled to receive the salary of the chairman as chairman. During this period of time, he is entitled for the salary and privileges of the President of India. Election, it consists of both members of parliament, elected and nominated. In case of president, only elected members, but here nominated members too, they can be a part of this election. Then it does not include the members of state legislative assemblies. In case of president election, the elected members of state assemblies is also included. So in vice president election, 2 major points you should note it in your mind, that in this election, in case of president, only elected members are going to be the part of this election, but in vice president election, nominated members can also be a part of this. And the second point is, it does not include a member of state legislative assemblies, but in president's election, it can be included by the state legislative assembly members also. Now we will discuss about Supreme Court. In Article 124 to 147 in Part 5th deal with the Supreme Court. It consists of Chief Justice and 30 other judges. Senior-most judge of SC is appointed as CJ or Chief Justice by President. Other judges are appointed with consultation of CJ by President. And what are the qualities? You can say it should be a citizen of India and have been a judge of High Court for 5 years, or an advocate of High Court for 10 years, or in President's view, a distinguished jurist of the country. And Supreme Court is inaugurated on January 28, 1950. Okay. Then CJ and other judges hold office till 65 years, can give resign to president only. Okay. Salary of CJ is 1 lakh per month and other judges 90,000 per month. With the previous consent of President, CJ appoint ad hoc judges and may request a retired judge of SC or ST to sit or act as judge of Supreme Court. Judges got salaries from Consolidated Fund of India. Cannot practice after retirement. First CJ of India was Hiralal J. Kania and present CJ at that time R.M. Ludha. That was not correct. Now is, I think, Deepak something. Removal. What is the process of removal? Removal can be preferred before the House of Parliament. If it is in Lok Sabha, it should be resigned in by not less than 100 members, and if it is in Rajya Sabha, signed in by not less than 50 members. The resolution should be by a majority of total membership of both of the houses and by 2/3 majority of the members present and voting. Jurisdiction of SC. It has 5 jurisdiction, which is mentioned in Polity book of M. Laxmikant. Original jurisdiction, which is all about settles dispute between center and state and state. So if there is any dispute in between these two, so it might be state, or it might be central or state. So original jurisdiction helps SC. Then writ jurisdiction. It is for enforcement of fundamental rights as mandamus, habeas corpus, sorcery, etc. Appellate jurisdiction. It is again divides in subparts: constitutional, civil, and criminal. So constitutional appellate jurisdiction is if HC certifies case involves substantial question of law as to interpretation of constitution. Then in civil applied jurisdiction, if HC clarifies the dispute is not less than then rupees 20,000 or case is fit for SC. If in criminal, if SC has appeal for withdrawn of sentenced to death. Okay, adversary jurisdiction to give advice to president, and revisory jurisdiction, that is important. Article 137 is empowered to review any judgment or order to remove mistakes, and that is really very important. Revisory jurisdiction. The SC decides dispute regarding the election of president or vice president. To review its own judgment or order, the SC recommends the removal of members of UPSC to the president, ultimate interpreter of the constitution. Then PIL. What is PIL? PIL is public interest litigation. Anyone can now initiate a proceeding in the HC or SC for enforcement of constitutional rights. It can be filed through a simple letter, written or in a postcard. This derives from the right to heard as implied or mentioned in Article 32. Justice P.N. Bhagwati and Justice V.R. Krishna Iyer were among the first judges to admit PILs in the court. Constitution has not prescribed a minimum age or tenure for appointment as a judge of Supreme Court. Article 143, power of President to consult SC. SC, or you can say Supreme Court. Now here I'm going to mention CAG and then Attorney General. So CAG is the full form is Comptroller or Auditor General, which is mentioned in Article 148, appointed by President. Long administrative experience should be there with him, and knowledge of accounts is he can apply this post, or he should be appointed. It should be hold office for 6 years or till 65 years of age. He can't be removed only in the recommendation on the of two houses by president. His duties are to audit the accounts of the center and states and to ensure that nothing is spent out of the consolidated fund of India. He submit audits report to the center and states. CAG acts as the custodian and the trustee of public money. Three functions of CAG is to audit the government expenditure, to see that the financial rules and orders which have a bearing on governmental expenditure are obeyed, and to satisfy himself that those who section expenditure have the power to do so. Okay, then CAG submits three type of reports to president: audit or audit report, to an appropriation account, audit report on finance account, and audit report on public undertakings. So three reports were there: appropriate account, finance account, and public undertaking account. Okay, then Attorney General of India, in Article 76, it was mentioned, a highest legal officer of a union government, appointed by the president, qualified to be appointed a judge of SC. He is not given the right to vote in the parliament as a member of, if he is also allowed to take up private practice. He is not paid salary. This post changes after the term of government. New government appoint his choice. Okay, so it changed. If the government changed, then Attorney General should be changed. Right to vote in Parliament was not given to this Attorney General. He was not paid salary, and he was not member of Central Cabinet. These three things you should mention or remember. Attorney General is associated by two Solicitor General and four additional Solicitor General. His work to give advice on all such legal matters which may be referred or assigned to him by President. Appears before SC or HC in cases involving the Government of India. Every state shall have an advocate general to advise the government on legal matters. Article 165. This is about, you can say this is because of the Article 165. AG, or you can say Attorney General, is not a member of the Central Cabinet. Article 76 does not mention about the Solicitor General and additional Solicitor General. Okay, power of judicial review of Supreme Court. Okay, that was not mentioned earlier. So just look at what is it. Judicial review power of Supreme Court. It is the power of SC to examine the constitutionality of legislative enactments and executive orders of both of the central and the state governments. If they are violate of the constitution, they can't be enforced by the government, needed for the following reasons: to uphold the principle of the supremacy of the constitution, to maintain federal equilibrium or balance between the center and the state, to protect the fundamental rights of citizens. Phrase judicial reviews has nowhere mentioned in the constitution. Okay, then very small knowledge about Consolidated Fund of India and Contingency Fund of India. Consolidated Fund of India, it is a fund of to which all the revenues, loans raised and incomes of the Government of India are deposited. No money can be spent out of this fund except through the grants made by the Parliament and charge expenditure. These expenditures do not require the approval of Parliament and are sanctioned either by the Constitution or Act of Parliament. Article 112 Part 3 describes charge expenditures are. What are the charge expenditures? Emolument and allowances of chairman and deputy chairman, speaker and deputy speaker of Rajya Sabha and Lok Sabha respectively, salaries of and allowances of judges of SC, HC and CAG, debt charges for which Government of India is liable, and other expenses declared by the Constitution or Parliament. Contingency Fund of India, this is through an Act of Parliament in 1950 it was introduced. It has limit of rupees 50 crore. It is at the disposal of the President. if he meet unforeseen expenses, sanction of parliament not needed, he can issue this money. States have their own contingency and consolidated fund. So now I'm going to tell you something about Parliament. Parliament has three pillars. First is President, then Lok Sabha, then Rajya Sabha. So very first, President. He is not a member of either of the houses, but he is an integral part of it. Though President does not sit any parliamentary meeting, but he is an integral part of it, because a bill passed by both of the houses of the parliament cannot become a law without the President assent. Then something about Lok Sabha. Lok Sabha is something you called as lower house. It has a speaker. Okay, what is maximum strength? 530 states plus 20 UTs. So 550 plus 2, 552 is the number. Present strength is 545. Reservation for SC and STs is also there. 5-year term should be there. After it automatically dissolves. So Lok Sabha is dissolves, but in the case of Rajya Sabha it is not. Okay, directly elected by the people. It is a continuing chamber and age is somehow 25 years. What are the qualification? It must be an Indian citizen, not hold any office of profit, no unsound mind and insolvent, has it registered as voter in any parliamentary constituency. Then disqualification on the grounds of defecation and according to the Representation of People's Act. Then members' oath is administered by pro tem speaker. It can resign to the speaker also. 2 members are nominated by the president from Anglo-Indian community. Proportional representation not adopted. Territorial representation by direct election. Okay, and it has a speaker and deputy speaker. The 91st Amendment 2001 extended freeze on Lok Sabha and state assembly seats till 2026. Okay, so 91st Amendment. Then I'm going to tell you something about Rajya Sabha. Okay, so 4th schedule deals with the allocation of the seat in Rajya Sabha. Rajya Sabha is also called upper house. It is headed by chairman. What are the numbers? 250 is the number and 12 members nominated by president, and at present is the number is 245. No reservation for SCs and STs. That is very important point. In Rajya Sabha no reservation, but in Lok Sabha it has reservation of SC and STs. A permanent body and not subjects to dissolution. Lok Sabha dissolute, but here dissolution is not possible. Term is not fixed because dissolution is not there. It is a continuing chamber and age is 30 years. There the age was 25 years. Elected by the elected members of state legislature assemblies. Seats allocated to the states in Rajya Sabha on the basis of the population. Qualification are the same, like must be Indian citizen, not hold any office of profit, no sound mind insolvent, has registered as a voter in any parliamentary constituency, and elected by means of the single transferable vote. Okay, then all states plus UT of Delhi and Pondicherry are represented in Rajya Sabha. So be careful, all states plus Delhi and Pondicherry are represented in Rajya Sabha. Representatives of the state are elected by members of state legislative assemblies on the basis of proportional representation, though single transferable vote. It has chairman and deputy chairman and panel of vice chairman. Some very important term related to the parliament. 3 sessions should be there. What are the names? Budget session, monsoon session and winter session. Budget session timing is February to May, then monsoon session July to September, and then winter session November to December. Then some terms like quorum. It is the minimum number of members required to be present in the house before it can transact any business. It is 1/10 of the total member. Lok Sabha at least 55 member and Rajya Sabha it should be 25 members. Then business should be conducted. Okay, any business, any type of business. Then adjournment. It only terminates a sitting for a specified time, which may be hours, days or week or not a session. of the House. It is done by the presiding officer of the House. It does not affect the bill or any business, only resumed that. So adjournment means terminates a sitting, not a session. Okay. Then adjournment sine die. It means terminating a sitting of Parliament for an indefinite period. Okay. So terminating the sitting in indefinite period, you can say adjournment sine die, okay, without naming a day of reassembly or by presiding officer. Then prorogation. Prorogation is the term which is dealt by only president. Okay, it terminates the sitting and session too. So it means when prorogation done by president, it means it terminates the sitting plus session also of the house. It is done by the president of India and it also does not affect the bill. Okay, then dissolution. Unlike a prorogation, the dissolution ends the very life of existing house. A new house is constituted after general elections are held. It is done only in Lok Sabha, not in Rajya Sabha. As you know that Rajya Sabha is the not part of any resolution. Then lame duck session. Lame duck session is refers to the last session of the existing Lok Sabha after a new Lok Sabha has been elected. Those members of the existing Lok Sabha who could not get re-elected to the new Lok Sabha are called lame ducks. Snap vote. It refers to the vote taken unexpectedly with voters being briefed or informed about in advance. So vote taken unexpectedly, no information was there, so that is a snap vote. Then guillotine, due to lack of time, demand for grants are put to vote whether they are discussed or not in the house or on the last day of allocated time. It is called guillotine. And concludes the discussion on demands for grants. So because of the lack of time, demands for grants put on vote, that is guillotine. Then whip. What is whip? Every political party, whether ruling or opposition, has its own whip in the parliament. He is an assistant floor leader. He ensured attendance of the members are secured. Their support in favor or against of the particular issue. He regulates the monitors their behavior in the parliament. The members has to follow a whip, otherwise disciplinary action can be done. Then a speaker pro tem, that is what president appoints the senior most member of Lok Sabha at the speaker as the speaker pro tem. He has all the powers of a speaker. He presides over the first sitting of newly elected Lok Sabha. And then what are the duties? To administer oath to the new members and also enables the house to elect the new speaker. So this is all about Parliament. Next lecture I am going to tell you something about state legislature, then UPSC and finance. So here in the particular audio I am going to cover Parliament, second part 2. Okay, devices of parliamentary proceedings. So very first hour is question hour. First hour of every parliamentary sitting is called as question hour. This time the members ask questions and ministers usually give answer. So here three types of questions are there. Starred questions. Okay, so start questions requires only oral answers. Then unstarred questions, it requires written answer. Then short notice questions, giving a notice of less than 10 days. So this is type of three types of questions. Now 0 hour. In formal device, the 0 hour starts immediately after the question hour and lasts until the agenda for the day or regular businesses starts. In short time gap between question hour and the agenda is known as 0 hour. Okay, so time gap between question hour and agenda timing not mentioned in the rules of procedure. Motions are there, three principal categories are there: substantive motion, then substitute motions and subsidiary motions. So substantive motions are there: independent and important purposed proposal, independent and important proposal, ex dealing with impeachment of president or a removal of chief election commissioners. So this type of you can call it as substantive motions. Then substitute motions are substitution of original motion or alternative, and subsidiary motions, it has no meaning and cannot state the decision of the house. Then closure motion. Closure motion is the another one which is important one, by a member to cut short the debate on a matter before the house. So it is for closure motion, it is, you can say, it is tried to cut short the debate. So it has four kinds: simple closure, closure by compartments, and kangaroo closure, and guillotine closure. So here I'm going to define it one by one. Simple closure means matter having been sufficiently discussed be now put to vote, and then closure by compartments. If bill is lengthy, then debate covers the one part as whole, and the entire part is put to vote. Okay, and then kangaroo closure is called as only important clauses are taken up for debate and voting. Another part is skipped or passed. And guillotine closure is due to want of time. Undiscussed closure, or you can say also put on vote with discussed ones. So which are put on the vote without any discussion, those are called as guillotine closure. Then calling attention motion is what it exists since 1954, mentions in the rule of procedure. So as I have already told, 0 hour is not mentioned in any rules of procedure or any constitution, but this one, calling attention motion, is mentioned in rules of procedure of parliament. And what is it? Calling attention motion is to call the attention of ministers to a matter of urgent public importance. Then adjournment motion. This is to draw attention of the house to a definite matter of urgent public notice, or you can say public importance, needs or the support of 50 members to be admitted. The discussion on an adjournment motion should last for not less than 2 hours and 30 minutes. It should not cover more than one matter. Then it is extra ordinance, you can say it is an extraordinary device. Rajya Sabha can't use this device. So what is main important point is there that adjournment motion is not used by Rajya Sabha, it is used by only Lok Sabha. Okay, then no confidence motion. No confidence motion is talk about Lok Sabha can remove the ministry from office by passing a no confidence motion. The motion needs the support of 50 members to be admit. Then censure motion is there, and no confidence motion. So censure motion is to state the regions for its adoption, then moved against an individual minister or a group of minister or entire council of minister. Censure motion is we are talking about. Then censoring for specific policies or actions. If censure motion is passed in Lok Sabha, the Council of Ministers need not resign from the office. Then no confidence motion, this is really important, need not state the reasons. There is no need of to state any reasons against the entire council of ministers only. So no confidence motion you cannot starts with for any minister, it's for the whole ministry, okay, whole council of ministers, for ascertaining the confidence of Lok Sabha in the Council of Ministers. If it is passed in the Lok Sabha, the Council of Ministers must resign. So this is a, you can say, a particular, a very important difference in between these two, censure motion and no confidence motion. If no confidence motion is passed, then the whole Council of Ministers has to resign. Motion of thanks. This one is first session after each general election, and the first session of every fiscal year is addressed by president. So this is all about some parliamentary portion, okay, which I have left. Now I'm going to cover some more important portion, like the representation of a people's act, or you can say RPA 1951. So here I'm going to show some features like election offense, by elections, RPA for 1951, poll is there, actual conduct of elections, registration of political parties, election disputes are solved, administration machinery for the conduct of elections. RPA deals with the election system in India. This act was passed by Indian Parliament in before the very first general election. It provides the terms and qualification, disqualification of the members of the Lok Sabha and Rajya Sabha, and also the state legislature. Act prevents entry of criminal into the representatives body, at least on paper. This act amended many times. Original RPA contains 13 parts and 171 sections. Part 2 of this RPA deals with the qualification and disqualification of the members. Then part 4A, it's for registration of political parties. 5th A, for free supply of certain materials to candidates of recognized political parties. Part 13A mentions the chief electoral officer. Section 123 mentions about corrupt practices. So section 123. RPA 1950 offers for following conduct: qualification of voters, preparation of electoral rolls, delimitation of constituencies, then allocation of seats in the parliament and state legislature. Two major amendments done in RPA 1951 in 2013. These are: a person can file his nomination even though he is shunned, or you can say reject, from being voting, owing to be in jail or in police custody during elections or before. The second one is there, the past act has not defined on what ground a person can be disqualified. In this act, the grounds are clearly stated. If one is proved for any conviction of any one of the offences, then his or her name will be wiped off from electoral roll and shall cease to be a voter. Part 15 of Indian Constitution is elections, which includes Article 324. Election commissions is in Article 325, universal suffrage; Article 326, adult suffrage; Article 329, courts are barred from questioning the Delimitation Act brought by the parliaments. Now I'm going to tell you something about Finance Commission. Finance Commission is mentioned in Article 280. Okay, 280 is related with Finance Commission. It is a quasi-judicial body constituted by President every 5 years. A chairman plus 4 other members appointed by President. The members are eligible for reappointment. The chairman should be a person having experience in public affairs, and the 4 other members should be selected either a judge of HC or specialized in knowledge of finance and accounts, or experienced in financial matters and administration, or has a special knowledge of economics. Presently, 12th Finance Commission is working, whose chairman is C. Rangarajan. Functions: you can say Finance Commission is a constitutional body, and its function is distribution of the net proceeds of taxes to be shared between the center and the state, and also the allocations. The principles that should govern the grant in aid to the states by the center. Example, you can say out of the consolidated funds of India. Then the measure. Third one is the measures needed to argument or arrangement the consolidated fund of state to supplement the resources of panchayat and municipalities. Then recommendations are only of advisory nature, not binding on union government. Then the next one is the setting up of planning commission. Inevitably has a led a duplication of and overlapping of functions, and both of them. And the main functions of Finance Commission now consist in determining the revenue gap of each state and providing for filling up the gap by the scheme of devolution, partly by the distribution of taxes and duties, and partly by grant and aid. First finance chairman was K.C. Neogi, and it was there in 1951. Now we will deal with the election commission. Election commission consisting three election commissioners, okay, permanent and an independent body for free fair elections of parliament. Chief election commissioner plus two election commissioners were there. They all enjoy equal powers, salaries and allowances as the judge of Supreme Court. Appointed by President, Article 3824. Article 324 also provides appointment of regional commission. The term is, you can say, 6 years, not eligible for reappointment. Election commissioner can be removed by both of the houses with a special majority. Constitution has not prescribed the qualification, legal, education, administration or judicial anything, or and not specified the term of members of election commission. Now I'm going to tell you something about functions. To determine the territorial areas of electoral constituencies throughout the basis of delimitation commission, act of parliament, to prepare and periodically revise electoral rolls and register all eligible candidates, or you can say voters, to notify the dates and schedule of elections and scrutinize nomination papers, to determine the code of conduct for all parties. One important point is there that is missed. I'm going to tell you that booth level officer is what? BLO is a representative of Election Commission of India at a grassroots level. One BLO of one polling station location. You can say what are the duties of BLO? Assist voters to obtain or and become a voter card. Okay, have a voter card. Then interact with local people and representatives, responsible for mapping of person with disabilities and electoral rolls, and then prescribes notices at designated location, then distributes voter slip ahead of elections. On poll day BLO sits at facilitation desk and guide to polling stations. Then other functions I have to mention here. Some are missed. So next one is there to cancel polls in the event of rigging, both capturing or violence and other irregularities. Then election commission has the right to cancel the poll. Okay, then allotment of election symbols, then to supervise the machinery of election throughout the country to ensure free and fair election. Then election commission is associated by deputy election commissioners. They are drawn from the civil services and appointed by the commission with the tenure system. Then delimitation commission is very important. You can say it is as a boundary commission. For what it is to withdraw, it is to redraw the boundaries of the various assemblies and Lok Sabha constituencies based on the state is not based on a recent census. The representation from each state is not changed, but member of SC and ST seats are changed during the exercise. Its work or orders cannot be challenged into the court of law. The orders are laid before the Lok Sabha and representative state legislature assemblies. It have been set up 4 times: 1952, 1963, 1973 and 2002. 2002's delimitation commission set up after the 2001 census. Its chairman was Justice Kuldeep Singh. The commission has submitted its recommendation, and Karnataka is the first state where 2008 elections were held according to the 2002 delimitation commission. Today I'm going to cover NDC, NHRC, CBI and all institutions. So very first I'm going to start with NDC, National Development Council. It was started in 1952, August 1952 on the recommendation of first 5-year plan. It is neither a constitutional body nor statutory body. NDC composed of following members: very first PM, then all union cabinet ministers, chief ministers of all states, CM of all UTs, member of planning commissions. Objectives: to secure cooperation of states in the execution of the plan, to strengthen and mobilize the efforts and resources, to promote common economic policies in all vital spheres. NDC, some tasks you can say have some features like to prescribe guidelines for plan, to make an assessment of resources, suggest measures, recommend measures for achievement of target in the plan, review the working of national plan, to consider important questions of social and economic policy. NDC is the highest body below the parliament responsible for policy matters with regard to planning for social and economic development. Its recommendations are only advisory, not binding. Now is the turn to understand NHRC, National Human Rights Commission. It is a statutory body, statutory means Samvidhanic, established in 1993 under a legislation enacted by the Parliament, namely the Protection of Human Right Act 1993, which was amended in 2006. So NHRC appointed by president, one chairman is there and four members are there. So chairman should be retired Chief Justice of India and four members retired judges of SC or HC. Ex officio members: the chairman of National Commission for Minorities, the chairman of National Commission for SCs, then STs, chairman of National Commission for STs, and chairman of National Commission for Women. Term 5 year or until they attain 70 years. Okay, not eligible for further employment. Then headquarters in Delhi. It has all the powers of civil court. It can look into a matter within 1 year of occurrence. It has no power to punish the the violators of human rights, nor to award. So it has no right to punish or award. Then functions of NHRC, if we have some highlights, so inquire into violation of human rights. Then second point is to visit jails for investigating their living condition. Then to study treaties, okay, whatever the treaties signed between the states or international one, that encourage the efforts of NGOs, spread human rights literacy. Then review factors including acts of terrorism, recommend measures also. Performance of the commission, some here I'm going to share some performance by NHRC. So abolition of bonded labors, functioning of mental hospitals at Ranchi, Agra and Gwalior, then issues concerning right to food, child marriage restrained act 1929 and reviewed by it, abolition of child labor, trafficking of women and children, abolition of manual scavenging, right to right of disabled persons, and promotion of human right literacy and awareness in education system. Now it's time to understand CIC. CIC means Central Information Commission. It is established in 2005 through an official gazette under the provisions of RTI 2005. It is not a constitutional body, high powered independent body it is, and for one chairman, one chief commissioner, and not more than 10 information commissioners were there, appointed by president on the recommendation of committee consisting prime minister, leader of Lok Sabha, and union cabinet ministers nominated by prime minister. Then term 5 years or 65 years, not eligible for reappointment, and salary and allowances is equal to chief election commissioner. Then what are the powers and functions of CIC? It can receive and inquire to any complaint. It has the power of a civil court, may examine any record which is under the control of public authority, then imposing penalties under this act 250 rupees to 25,000 rupees. Then is seeking annual report from public authority. This much is all about CIC. Now we will move forward national commissions and central bodies and related ministries. So here I'm going to tell you which some commissions and bodies and in which ministries these are fall. Like Central Information Commission, CIC, fall in Ministry of Personnel, Then UPSC, SSC, CBI, Central Vigilance Commission or CVC falls in Minister of Personnel. Then National Investigation Agency, it is falls in Ministry of Home Affairs. NIA, okay, Ministry of Home Affairs. Then zonal councils and NHRC, these are also falls in Ministry of Home Affairs. Then National Commission for Women and National Commission for Protection of Child Rights. These two ministries, these two bodies falls in Ministry of Women and Child Development. Okay, now is the turn to understand what is CVC, Central Vigilance Commission, and then after I'll explain CBI. So Central Vigilance Commission, it is the main agency for preventing corruption in the central government. Established in 1964, was recommended by Sanathanam Committee on Prevention of Corruption. 1962 to 64. So CVC established in, you can say, 1964. Some points are important which I am going to tell you. Neither constitutional body nor statutory body, okay, free of control from any executive authority. It consists a CVC chairman and not more than 2 vigilance commissioners appointed by president on the recommendation of our 3-member committee. Prime Minister plus Union Ministries of Home Affairs and plus leader of the opposition of in the Lok Sabha. Then term is 4 years, 65 years, or you can say not eligible for further employment. Then salary allowances are similar to those of chairman of UPSC. CVC is also chairperson of 2 committees, Director of Delhi Special Police Establishment and Director of Enforcement. CVC has its own secretariat, Chief Technical Examiners Wing, you can say CTE, and a wing of commissioners for development and inquiries. This is CDIs. Okay, headquarters in at Delhi. New Delhi, it has the powers of civil court. CVC has to present annually to the president a report on its performance. Some functions are there. Some functions may be highlighted as to inquire or investigate if a central government employee has done any offence under Prevention of Corruption Act 1988. CVC also consulted by central government in vigilance and disciplinary matter to review the progress of investigations conducted by Delhi Special Police, to exercise superintendence over the functioning of Delhi Special Police establishment. Okay, so now it's a turn to understand CBI, Central Bureau of Investigation. It was established in 1963. Okay, so it was set up in 1963 by a resolution of Ministry of Home Affairs, later transferred to Ministry of Personnel. So when it was established, it was in Ministry of Home Affairs, but after that it was transferred in Ministry of Personnel. Then recommended by Sanathanam Committee, the same committee which was we have read already in CVC's establishment. Okay, so it was recommended by Sanathanam Committee on Prevention of Corruption 1962 to 64. It was not a statutory body. It derives its powers from Delhi Special Police Establishment Act 1946, headed by a director. It has motto, vision of CBI. We have some highlighted points. So very first is combating corruption in public life, evolving effective systems and producers for successful investigation, helping fight cyber and high technology crime, upholding human rights, protecting the environment, art, ethics and heritage of our civilization, then supporting state police organization and law enforcement agencies. Then organization of CPI, it has following divisions: anti-corruption division, economic offense division, special crimes division, policy and international police cooperation division, then administration division, then a directorate of prosecution and central forensic science lab. It in total it has 5,000 staff members, 125 forensic scientists and about 250 law officers. The director of CBI has been provided security of 2-year tenure in office by CVC Act 2003. CBI Academy is located at Ghaziabad, UP, and started functioning in 1996. Three regional training centers at Kolkata, Mumbai, and Chennai. Functions of CBI we have highlighted as investigating cases of corruption, bribery, misconduct of central government employees, then taking up a request of state government. Okay, if any case is there and a state government requested to CBI, then it can take that case. Then investigating serious crimes and having national and international ramification. Okay, then coordinating the activities of anti-corruption agencies and various police forces. Then investigating cases relating to fiscal and economic laws like breaches of export import control, customs and excise, income tax, and foreign exchange regulations, and so on. Okay, so this much is all about. In next audio I'm going to deal with Lokpal and Lokayukta. Thank you, thanks a lot, take care. Okay, now today I'm going to tell you something about Panchayati Raj. So Panchayati Raj is mentioned in 73rd Amendment Act. Okay, and it was a constitutionalized through the 73rd Constitutional Amendment Act of 1992. Balwant Rai Mehta Committee in 1957 recommended the establishment of the scheme of democratic decentralization, which ultimately came to be known as Panchayati Raj. Okay, and its main recommendations, you can say 3D structure is also important. When we discuss about Panchayati Raj, 3D structure is very important. First one is decentralized, the second one democratic, and third one development. Now I'm going to tell you something about recommendations of Balwant Rai Mehta Committee. 3-tier structure. Okay, 3-tier structure. In these tiered structure, first one is Gram Panchayat, the second one is Gram Samiti, and third one is Jila Parishad. And in Hindi you can say village level, block level, and district level. So directly elected representative are there in Gram Panchayat. Okay, directly elected, and in Panchayati Samiti and Jila Parishad, indirectly elected members are there. Okay, then genuine transfers of power and responsibility to their institutions, adequate resources to them and power. Then you should provide all social and economical development programs channelized through these Panchayati Raj. Then first state that adopted 3-tier system was Rajasthan, Nagpur district in 1959. Okay, then Alok Mehta Committee recommended something more. Now I'm going to tell you something recommended by Alok Mehta Committee. In 1977, Janta government appointed Alok Mehta, and he recommended 132 recommendations, where he supported 2-tier system, Jila Parishad at district level and Mandal Panchayat, consisting of a group of villages with the total population of 15,000 to 20,000. And its recommendation was the Panchayati Raj institutions should have compulsory power of taxation to mobilize their own financial resources like profession tax, entertainment tax, and etc. Seats for SC and ST should be reserved on the basis of their population. A minister for Panchayati Raj should be appointed in the State Council of Ministers. The NA Panchayat should be kept as separate bodies from that of Development Panchayat. And the next one is the chief electoral officer of a state is consultation with the chief election commission should organize and conduct the Panchayati Raj elections. So Alok Mehta Committee provide election process of PRI. Okay, the PRI you can say Panchayati Raj institutions. Okay, then reservation for SC and ST. Yes, sorry, SC only. SC and ST. And then finances, taxes, and consultation of PRI. It's very important. Then 73rd Amendment of Act 1992 added a new part 9th to the Constitution. It constitutes Article 243 to 243O. The Act has added 11th schedule, comprises 22 subsects to the Constitution's features. Act provides for the Gram Panchayat as the foundation of the Panchayati Raj system. Act provides 3-tier system. Okay, and it means like in our modern India we have three-tier system, which you can say gram panchayat and panchayat samiti and jila parishad. Okay, district panchayat. So village level, then block level, and then a district level. All the members of panchayat at the village, intermediate and district level shall be elected directly by the people and chairman elected indirectly by its members. Act provides reservation for SC and STs, 5-year term of the panchayat. Then election can be done by state election commission, and the act bars the interference of court in the electoral matter of panchayat. Reservation of 1/3 seats for women, like reservation of 1/3 seats for women in panchayat at all three levels. PISA is, you can say, our act. What is it? PISA means PESA. It means Panchayat Extension to the Scheduled Areas Act of 1996. It is an extension act which has the objectives. These are to provide self rule for the bulk of tribal population, to Gram Sabha, a nucleus of all activities, then to safeguard and to preserve the traditions and customs of tribal communities, and to empower panchayat with its specific power conducive to tribal communities, or you can say tribal requirements. Now today I'm going to deal with the municipalities, which is 74th amendment of constitution. Okay, so some important features, you can say urban local government constitutionalized through 74th amendment act 1992. It dealt with three ministries: Ministry of Urban Development, Ministry of Defense in the case of cantonment board, and Ministry of Home Affairs in the case of UTs. So, and it covers article 243p to 232 Z. I think something wrong is here. I'll tell you later. Okay, I think some articles are wrong. When I'll correct it, then after I'll tell. Now move forward the another one. In 1687-88, the first municipal corporation in India was set up in the Madras. Lord Ripon resolution of 1882 has been added as a Magna Carta of self-local government. He is called the father of local self-government in India. So who is the father of local self-government in British India? You can say Lord Ripon. P.V. Narasimha Rao government introduced the modified municipalities bill in Lok Sabha September 1991. It was emerged as 74th Constitutional Amendment Act 1992 and came into force on 1st June 1993. Minimum age of voter is 18 years and stand-in election should be 21 years old. Then 74th Amendment Act 1992 has added new part 9th A and it deals with the article 243P to 243G. Okay, so here 243P to 243G, it is also added a new schedule, 12th schedule, which contains 18 functional items. Okay, then features three types of municipalities: Nagar Panchayat, Municipal Council, and municipal corporation, which is a larger one. Okay, so in the very base level, you can say Nagar Panchayat. When you make a triangle, so at the very base level it is Nagar Panchayat, then the upper level is municipal council, and the smaller level is, you can say, the broader area, it's municipal corporation. It is a head up of all these three. All the members of municipality shall be elected directly by the people of municipal area. Reservation for SC and ST is there. 1/3 seats for a woman also reserved there. Then term of 5 years, which is written in 243U. The Finance Commission for the net proceeds of the taxes, duties, tolls and fees levied by the state and municipalities. Then the act does not apply scheduled areas and tribal areas of states and also not affect the Darjeeling and Gorkha Hill Council of West Bengal. Then every state shall constitute a district planning committee. And next one is the act bars the interference by courts in the election of municipalities. It starts from first meeting. If dissolute election done, then who will be chosen come for only left years they can do the duty. Now types of urban government. Types of urban government, you can say first one is municipal corporation. In big cities, it has three authorities: the council, the standing committee, and municipal commissioner. So the council is directly elected people headed by a mayor. Okay. And the standing committee, day to day working committee. And municipal commissioner may be an IS. And Delhi, Mumbai, Bangalore and Calcutta. These in these cities it may be function. And the term of mayor should be for 1 year according to state legislature law. Then municipalities you can have towns and smaller cities. Its authorities are the council headed by president or chairman. It is not mayor. Okay, when we are talking about municipalities, there is no mayor, but when we are talking about municipal corporation, then it should be headed by mayor. Then standing committee is there in the municipalities and chief executive officer. Notified area committee, in a fast developing town, smart city or industry, something it is added. Then town area committee, it is set up for the administration of small towns. Or it might by SL, you can say semi municipal authority or public work or local admin. Then cantonment board, it is for civilian population in cantonment. Then township, housing colonies of itself and workers of plant like sail and bale. And then port trust, established in the port areas, and a special purpose agency here, that is these areas are like smart cities of government, function based on not area based. Okay, and its housing projects are there like town improvement trust and housing boards, electricity boards, urban development authorities, water supply boards, and etc. So here eight types of urban governments are: municipality corporation, municipalities, then notified area committee, town area committee, then cantonment board, then township, then port trust, and then special purpose agency. Municipal corporation divided in three sections, you can say separate personal system, unified system, and integrated system. So separate one is there. Each local body appoints and administers and controls, not transferable. Then unified system, appointed and control but transferable, like Andhra Pradesh, UP, Tamil Nadu, Madhya Pradesh, and Rajasthan, and so on. An integrated system, both appoints, transferable, Odisha, Bihar, Punjab, Kolkata, and so on. 3-tier structure. Article 243R describes about the election process, direct election and state legislature. Then reservation for women is also there, SC and ST, and then 1/3 of according to the population for SC and ST. OBCs, you can say SC, BCs according to the state legislature and government. Yeah, I'm going to start Lokpal and Lokayuktas. Lokpal is on ministers or securities. You can call it ombudsman. And Lokayuktas on high officials. So ombud is a Swedish term and refers to a person who acts as the representative or spokesman of another person. The Administrative Reform Commission ARC of India 1966 and 70 recommend the setting up of two official authorities designated as Lokpal and Lokayuktas. The Lokpal would deal with the complaint against ministers and secretaries and at a central and state level, and the Lokayukta would deal the complaint against other specified higher officials. According to ARC, Lokpal would be appointed by President after consultation with the CJ, or you can say Chief Justice of India, the Speaker of Lok Sabha, and Chairman of Rajya Sabha. Features, you can say it is independent, impartial, non-political appointments. Then proceedings should not be subject to judicial interference. Then deals with the acts of injustice, corruption, and favoritism. Then investigations should be private and should be informal in character. Many of bills introduced in Parliament in between 1968 and 2011 to 1968 to 2011, but none of bills were passed by Parliament due to one or another reason. The Lokpal Bill 2011 provided provides a uniform vigilance and anti-corruption roadmap for the nation, both at the center and states. Lokpal and Lokayukta Bill 2011 was passed with certain amendments. So today I'm going to discuss Lokpal and Lokayukta Bill 2011. The bill seeks to provide for the establishment of a body of Lokpal for the Union and Lokayuktas for states to inquire into allegations of corruption against certain public functionaries and for matters connected therewith or incidental thereto. Lokpal to consist of a chairman and up to 8 members and not less than 50% of the members to be from SCs, STs, OBCs, minorities and women. So this is really point should be noted that Lokpal and Lokayukta Bill 2011. The bill seeks to provide for the establishment of a body of Lokpal for the Union and the Lokayuktas for states to inquire into allegations of corruption against certain public functionaries and for matters connected therewith or incidental. Therefore, Lokpal to consist of a chairman and up to 8 members and not less than 50% of the members to be from SCs, STs, OBCs, minorities and women. Lokpal to have under it an independent inquiry and prosecution wing, separation and investigation from prosecution. Lokpal to have power of superintendence and directions over any investigation agency including the CBI. No prior sanctions required for launching prosecution in cases inquired by Lokpal. To provide for Lokayuktas in the states on similar lines, enhancement of minimum and maximum punishment under the Prevention of Corruption Act from 6 months to 2 years and for from 7 years to 10 years respectively. Lokayuktas, many of the states have already set up the institution of Lokayuktas. It was established first in Maharashtra in 1971. So Lokayuktas is firstly started in Maharashtra in 1971 till now 2013. 18 states and one union territory have established the institution of Lokayuktas. The Lokayuktas and up Lokayuktas are appointed by by the governor of the state. We should consult of a chief justice of the state and the leader of opposition in state legislative assembly. Tenure you can say 5 years or 65 years. Lokayukta is responsible to the state legislature. He presents annually a consolidated report on his performance to governor. Recommendations made by the Lokayuktas are only advisory. Interstate relations, we have interstate water disputes, Article 262, interstate councils, Article 263, interstate trade and commerce, it is mentioned in Article 301, and interstate public acts, records and judicial proceedings are it's mentioned in Article 261. The Janata Dal government headed by VP Singh established the Interstate Council in 1990. Interstate Council in 1990. Chairman that time is Prime Minister, new Union Minister as a chairman. Then meet at least thrice in a year. Thrice, 3 times in thrice in a year. And then zonal councils, it is a statutory body, a specialist is established by State Recognition Act of 1956. Act divided country into 5 zones and provided each a zonal council. North zonal council member states are Delhi, Rajasthan, Jammu and Kashmir, Himachal Pradesh, Haryana, Punjab, and it's headquartered in New Delhi. Then Central Zonal Council, it covers the states of UP, Uttarakhand, Chhattisgarh, and Madhya Pradesh. It was headquartered in Allahabad, or you can say Prayagraj. Then Eastern Zonal Council, it covers Bihar, Jharkhand, West Bengal, and Orissa. It's headquartered in Kolkata. Then Western Zonal Council, it covers Gujarat, Maharashtra, Goa, Dadar Nagar Haveli, Daman and Diu, and it is headquartered in Mumbai. Then Southern Zonal Council, it covers Andhra Pradesh, Karnataka, Tamil Nadu, Kerala, and Puducherry, and it headquartered in Chennai. Each zonal council members have home minister, chief ministers of all the states in the zone, two other ministers from each states in the zone, and then administrator of each duties. Then home minister is a common chairman of five zonal councils. So who is the common chairman of five zonal council? You can say home minister. Now it's time to understand what is prime minister and what are its tasks. Prime minister is a real executive authority, de facto executive of head of the government, appointed by president of India, the leader of the majority party in the Lok Sabha as the PM, or you can say prime minister. He gets the salary and allowances that are payable to the member of parliament, head of the councils of ministers, union councils of ministers. He was headed by he was head of he is head of the union's council of ministers. He recommended persons who can be appointed as ministers by the presidents. He advises the president with regards to the appointment of important officials like Attorney General of India, Comptroller General, Editor General, or you can say CAG, plus chairman and members of UPSC, plus election commissioners, chairman and members of finance commission, and so on. PM is the leader of lower house. He can recommend dissolution of Lok Sabha to a president at any time. He is the chairman of Niti Aayog, NDC, NIC, or you can say National Integration Council, Interstate Council, and National Water Resources Council. He plays a significant role in shaping the foreign policy of the country. He, or you can say PM, is the master of government. It was said by H.R.G. Grevas, and next statement is said by Lord Morley. He said, a keystone of the cabinet arc. Then Article 74 declares Council of Ministers to aid and advise President. Article 77 conducts of business of the Government of India. The people, Morarji Desai, Charan Singh, VP Singh, Narasimha Rao, S.D. Devgowda, become PM after being CM of their respective states. Chief Ministers, Article 164. CM appointed by the governor. CM may be a member of any of the two houses of any legislature, state legislature. Term not fixed, cannot be dismissed by governor as long as he enjoys the majority support in the legislative assembly. But if he loses the confidence in the assembly, he must resign. He guides, directs, control, and coordinates the activities of ministers. CM, we have some where he headed chairman of state planning board. CM is vice chairman of the concerned zonal council by rotation, holding office for a period of 1 year. Political head of the service, and chief spokesman of the state. The total numbers of ministers, including CM in the Council of Ministers in the state, shall not exceed 15% of the total strength of the Legislative Assembly of the state. But number of ministers, including CM in the state, shall not be less than 12. This provision was added by 91st Amendment of 19th Amendment of 2003. Presiding officers of Parliament, Lok Sabha and Rajya Sabha. So Lok Sabha you can say is Speaker and Rajya Sabha is Chairman. So I'm going to give you some differentiation how we could discriminate these two power of the Speaker and Chairman. So Speaker elected by amongst its members, while Chairman, Vice President of India, is the ex officio of Chairman of Rajya Sabha. So here elected by the members, and here Vice President, who's become the Vice President, he itself ex officio Chairman of Rajya Sabha. The Speaker remains in office during the life of Lok Sabha. The Chairman only removed if he is removed from the Vice President. So when he removed from the Vice President office, he itself removed the Chairman of Rajya Sabha. Derives the power from the three sources. Speaker derives the power from three sources: Constitution of India, rules of procedure. Second one, conducts of business of Lok Sabha, and third one, parliamentary conventions. Rajya Sabha chairman is not a member of the house. Okay, so it's very important. Rajya Sabha so chairman hai, that is not the member of house. Then a speaker does not vote. Only casting vote in the case of tie. In the same way, Rajya Sabha also the same, does not vote. Casting vote is if tie. Then Lok Sabha Speaker decides whether a bill is money bill or not. His decision is final. In the case of Rajya Sabha, there is no such power given to Rajya Sabha chairman. Then the speaker decides over a joint sitting of two houses of parliament. So, whenever the joint sitting of Lok Sabha and Rajya Sabha occur, Lok Sabha Speaker is going to be the presiding officer of that joint sitting. But Rajya Sabha, there is no power, such power given to Rajya Sabha's chairman. I think it's over now.